Hello, good evening. Good evening, everyone. How are you hearing me? Good evening, how are you hearing me?
Good evening. I can hear you.
All right, thank you very much. It's nice saying that we already have joining in, even though the number is quite poor. We'll just try to see if we can get more people to join in for the call. Let me send a message. Let me send a message to the group and we can get more people to join. All right, good evening, everyone. Welcome to class. We are currently in week 5 of the JIIPCC Mentorship and Internship program, and it's always an amazing time in class, seeing all of us joining and having to have a great session. We hope that this session is going to be interactive. We have, I think, two mentors lined up for today's class. They are not yet here, but they will be joining us shortly, and we look forward to a very great session. So officially, this is the last class for the entertainment business and law class, right? The subsequent sections we'll be having after this are going to be combined classes, right, with the rest of the mentees within the other groups or within the other courses rather. So just kindly note that this is officially the last class, and just to get a sense of everything that has been going on from week 1 down to week 5. In week one we discussed music film business and law, yeah, where we handle things around film royalties, production, post production, and everything that goes on within the movie industry. And then in week 2, um, we talked about music business and law. And in music business and law, we also highlighted some of the industry standards within the music industry, stuff that goes on within the music industry, royalties, law, contracts, and the likes. We handled all that in week 2. In week 3, we had fashion business and law, and Miss Venice did a great job running us through what the fashion industry entails, the ins and outs, what we need to know pertaining intellectual property, ownerships, and just the likes also within um, music, sorry, fashion business and law. And for last week we had comedy skits and digital content, and it was also an incredible class. So this week our topic for this week is visual photography and visual arts, right? So yeah, we would be running through just everything we need to know around the visual arts industry, what it's like, photographers, how money is made, content, and also I'm sure there are going to be talks and highlights about creations around AI and what that is going to be looking like in modern times. So I truly hope that we sit in and have a great time in class. I noticed that participation so far has not been the greatest in recent times. I would want to assume that it's because we have come so far and the should I say the ginger, if I were to use that word, is beginning to go down and is a little bit low. But I really want to encourage us that everything that we have learned so far coming from the funds now has just been bits and parts of the puzzle in that sense, in the entertainment industry, right? Every part seems to be significant within itself, and if you miss one, you are missing something out of the whole lot, right? So please let's be encouraged to follow through with what we have set up for you within the program, and I'm sure it's going to be rewarding within that sense. So not to waste any time, I would like to introduce our mentors for today. Sorry I did not introduce myself. Like you know, my name is Dennis Williams, and I will be a moderator for today's class. Our first mentor that we're expecting in class today Our first mentor that we're expecting in class today is none other than Adedumadu. Adedumadu is lawyer and also whose legal practice focuses on corporate commercial law, which is specialized focus on arts law. He is the managing partner at Adedumadu and Co, a general practice firm, and leads on matters across sectors in Nigeria. Adedumade is also the founder of Legal Nigeria, a justice innovation startup that is making access to justice easier for users, lawyers, and non-lawyers. By allowing them access to legal service, and an online dispute resolution (ODR) mechanism to help parties negotiate and resolve disputes. Legal Nigeria is also helps lawyers advance their legal careers as well. Adedumade has represented a varying degree of clients in several matters before different courts in Nigeria, including banks, corporate organizations, government agencies, and state governments. Adedumade has represented clients before arbitration panels and election tribunals. In 2022, Adedumade was awarded the Outstanding Young Professional Award at the Nigerian Legal Awards. Adedumade was a member of the Nigerian Bar Association Digital Committee and is currently a member of the NBA Lagos Media Advisory Committee for the Review of National Cultural Policy of Nigeria, appointed by the Ministry of Arts and Culture and Creative Economy. Adedumade is the author of the book Legal Rights and Obligations under Nigerian Law and social media for lawyers. So Adedumade is going to be our first mentor for today. Hopefully he'll be joining us very, 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 very soon. Um, all right. I please hope we can all hear me. I would like to
Yes, we
confirm.
can hear you.
All right. So our second mentor for today is none other than Onajite Oluwafunke Udiete. Onajite is a film and TV business executive, an entertainment lawyer experienced in content licensing, acquisition, and distribution of film and TV programming for exploitation of rights by various on-demand and paid TV platforms. She runs Legal Plugs, a consultancy, a consultancy, sorry, a consultancy firm where she specializes or they specialize in providing tailored legal solutions exclusively for creators such as music artists, fashion designers, writers, or content creators. Their mission is to protect your creative endeavors and empower their clients with knowledge and to support them to thrive. Onajite has an impressive track record as a legal and business leader in media, film, and TV. She has helped supervise several short films and theatrical productions such as Balls, um, Grasso, the one for Sarah, EJ, and upcoming future films The Weekend and Kilometer 17. She started her career in distribution as a content acquisition intern at Premium Box Office TV and now currently works at Ebony Live as a legal executive for the company. So Onajite is going to be our second mentor for today. For some reason, Okay. So you can search, okay, for the question that was asked, I think you can search, you can go through our LinkedIn page. We have all our mentors flyers posted there and they are being tagged. So you can always reach out to them via the posts that we make. You can follow us on LinkedIn. It's just on J at JIIPCC. But if you search for us, you're going to see us. We post the weekly files of our mentors are posted there and they are also tagged for the session. So you can always reach out to them privately through that platform. So just check our LinkedIn page, and I'm sure you'll be able to gain access to the mentors. All right. Okay, so I'm back. Sorry about that. So not to waste any time, seeing that we have our mentors going to be a little bit late for the session today. We're following up with them to ensure that they join in, and we're able to have our session run with them also. Please, can we just, we'll start by having presentation. Oh, okay, no, firstly, let's take a quick, let's take pictures, right? I think that will be, I think the best way to go firstly. So please, kindly, before we take the presentation, right, let's take pictures. So for those on the call, please, if it's possible, can we have our videos on, right, pictures, just to start out with that, and then we'll continue as thank you, Shizoba. Chigozie, sorry. Please, can we have more videos on it? We're doing this for the sake of those, um, please don't get that before. Please, can we have more videos on it? Can we have more videos on it? Videos. Thank you as you respond. I want to assume we just don't have one person in class. Please, if you can, kindly turn on your video. Thank you, Pina. Okay, can we have a few more people join in? Right, let's cooperate, please. Okay. Okay, I'll be taking one more. All right, so we are done. Thank you, everyone. So what we're going to do is we're going to start with presentation. Right, we're going to start with presentation. One, or if I'm mistaken, once present let's start with presentation, and subsequently over time we will take the presentation for two, and then as our mentors join.
Mr. Dennis, it appears your voice is too low, Mr. Dennis. It appears your voice is too low. I don't know if it's to my end alone.
I'm coming. Just give me a minute. Or is this better?
Yes, it's better.
All right, thank you. All right, so please, we'll be taking presentation. All right, so group presenter in class, please kindly go ahead and start your presentation. Subsequently, after we've taken group presentation, our presentation has been sent to the mentors, so we'll still be getting feedback from them, and then we'll also take questions and their presentation. So please, let's get to it and start presentation. So group presenter for group one, right? Please, can you go ahead and start your presentation? If we don't have the group presenter for group one in class, can we have the group presenter for group two?
Yes, good evening.
Good evening. Please, let's go ahead and start with our presentation.
Okay, could you help me share your screen? Is it possible?
That will be possible. Give me a moment.
Okay, thank you very much.
Sorry, sorry, I'm taking a little bit of time. I'm trying to get that.
Okay.
All right, so can you see my screen?
Yes, I can.
All right, please go ahead.
Okay. Good evening, everyone. The topic for the week is protection and monetization of photography and visual artworks. And for us, our subtopics are cultural heritage preservation through digital reproduction, licensing and royalty models for photographers and visual arts, um, and legal challenges in online platforms. So we shall begin with cultural heritage preservation through digital production. Um, Digital reproduction of photograph and visual artwork is a very important and very crucial way of preserving cultural heritage. And because a lot of things have transitioned and a lot of inventions have taken place, they are also very convenient these days and provide a rich archive of our cultural heritage when they are preserved through this way. So among the strategies for effective digital preservation are high resolution imaging. This simply involves taking photographs of these cultural artworks. These days, even our iPhones these days are very, very, very capable in terms of photography. Samsung, we have a lot of phones that can take high resolution images. We no longer need to go look for cameras. Another way is metadata and documentation. This simply means providing proper documentation and giving the context, authorship, historical significance of these artworks. And it is in relation to the first strategy, which is high resolution image. Of course, when you take the image and put it out there, it is important that for a better understanding of what the picture is about, you give some description about the image that you have put out there. Then you talk about cloud and blockchain storage. Um, it is very easy and accessible because many platforms now have cloud storages. Android for something like Xiaomi has their Xiaomi Cloud. For iPhone users, there is the iCloud. So when these are stored there, they are secure. And what it just requires for you to access them is for you to type in your login details and you have access to them. And there is also the blockchain storage. This simply means minting the image, well, these days as an NFT on a blockchain, and it gives it an immutable existence. It is there and accessible whenever, wherever you like. Now, there are challenges and some ethical concerns in relation to digital storage, and there is the issue of authenticity. Um, when it comes to digital images, so questions arise as who is the original owner, um, how to differentiate between original copies and photo and replications of the originals. So it's a concern. There is also the problem of access and copyright dilemmas. Now, by the provisions of the Copyright Act, it is the person, the photographer, that owns the copyright to the image. Now, it becomes a little dicey here because we are talking about a cultural heritage. Yeah, you are the owner of the photograph, but we are talking about the heritage of a people, and these people will also like to have access to that preservation you have given to their culture, to that preservation you have given to their identity. So it becomes difficult to balance this. The photographer wants to claim ownership of the copyright. The people, the owner of the culture, would like to also have access to what belongs to them. Now, there is also the issue of AI. These days, AI, all you need is just for you to go type in the description of the image you want, and then it can be generated for you. So that poses a very serious problem to digital storage. We go to the next one, which is licensing models for photographers. Um, One of the major concerns of copyright and intellectual property as a whole is money. I mean, people want to be compensated for their creation. So licensing model, they provide a legal avenue, it's a legal means for licensees to use an artwork under specified terms, and also for the owners of the copyright to be compensated properly, the owners of the intellectual property, for them to be compensated properly when the licensees make use of their creations. Now, there's the royalty-based licensing. So when we talk about royalty-based licensing, this ensures that the owner of the copyright receives a percentage of the income that comes from the work, from the licensee's usage of the work. And this provides a continuous means of income to the owner of the copyright. And there are different royalty structures, and there is the fixed royalty rate. And in this instance, there is a predetermined percentage of income that is paid to the royalties. In this instance, it depends on the volume of usage or the volume of sales of that particular artwork. That is what determines the royalty that the owner of the copyright is going to be paid. Then there is the per use royalties. Now, this one depends on now the owner of the copyright in this instance is paid based on each usage of the artwork. So, in as much as this particular model provides a sustainable income for the intellectual property owner, there is a problem of monitoring, that is observance. I mean, you have to keep in touch, you have to keep a track of the usage or the sales of your artwork so that you'll be able to know how widely it has been used and what you are entitled to. Another model is the subscription-based models. This instance is in relation to online platforms. Like example, we have the Adobe Stock. There is also the Shutter Stock. These platforms, they provide an avenue for artists to upload their work, and then users come and subscribe. So it is through the subscription that the owner of the intellectual property gets paid. Another model is the stock photography and micro stock platforms. Um, it's also similar to the first one, to the second one, which is the subscription based. Now, these platforms, they are kind of a marketplace. They provide an avenue for artists and photographers to sell their work to a very broad audience. And under this particular form of licensing, there is the royalty-free licensing, in which the owner of the copyright is given a one-time payment for an unlimited use of the image. And even though the use of the image is not exclusive, there is also the rights managed licensing, which in which the income is based on factors like how widely it is used, whether or not the license is an exclusive license or not, the distribution rate and the description scale and all that. These licensing models, they have impacts on revenue generation and also on the artist's protection. Example, one of the ways it has an impact on the artist revenue and protection is revenue potential. Now, if there is an exclusive licensing, sometimes or most times it comes with a one-time payment, and this is different from this is different from the subscription based. So the subscription based, the payment comes at intervals. So it is now left for the artist or the owner of the copyright to determine which particular model best suits his or her interest. Now, there's also the need for legal protection. I mean, clear contract should be drawn so that the owner of the copyright knows what is being given out and what he or she is going to receive in return. These platforms, online platforms like the Shutterstock and Adobe Stock, they provide a market for the copyright owner to reach a wide reach of audience. So utilizing these platforms gives the photography, the preservation, the digital preservation of cultural heritage. If it gives it a wide audience, a wider reach. Now, there are some legal challenges in relation to online platforms, and one of them is the terms of service. Um, Normally, these online platforms have their terms of use. In fact, many online platforms do this. When you log into a website, you are prompted to agree to some terms and services. Now, if care is not taken, the owner of the copyright may agree to some terms that he did not pay attention to, because at the end of the day, there is an inequality in bargaining power. The agreement is there for you to sign. It is a take it or leave it offer. You may not be able to get the owner of the platform for you to sit down and negotiate. So in relation to this, the owner of the copyright should pay attention to the terms and services so that he or she doesn't sign his or her rights away without knowing. There is the issue of copyright infringement. In this scenario, because of how widely used the internet is, the wider the audience, the greater the possibility of infringement. So they say that in every 12 that there is a Judas. Now you can imagine how many 12 people that there are among the online users. and you can also from there count how many Judases you are going to get. So online platforms, they provide a wider reach. There's also the problem of also making the work open for infringement. Now, another challenge is the platform liability. Now, when these works are uploaded online, especially when they infringe on the owner of the copyrights, I mean the right of the owner of the copyright, it is the person who uploads the image that is held liable for copyright infringement and not the platform. And in this scenario, it becomes difficult to begin to track each person one after the other. Had it been it was the platform, except in situation whereby the platform is the one responsible for uploading the image. But in this case, it becomes problematic tracking each copyright infringer. There's also the problem of monetization. Like I said before, many of these offers are take it or leave it offers. I mean, you may not be able to sit down with the owner of the platform to negotiate your monetization. And also sometimes some of these people, they change their policies. So it becomes a problem because of the inequality in the bargaining power between the owner of the copyright and the platform owners. There's also the issue of jurisdiction in relation to this. The Copyright Act in section 45 sorry, 54 provides the means of taking down or infringing copies of online copies from digital platforms. But the problem now is that jurisdictions differ. And somebody may be in America and has used your image in an unauthorized manner, and you are in Nigeria. So sometimes there could be clashes in enforcement mechanism among jurisdictions. So that poses a big challenge. So with this, I've come to the end of the presentation. Thank you very much.
Thank you very much, Mr. Chigozie, for that. Thank you so much, Mr. Chigozie, for that wonderful presentation from your end. Well done to you and your team for putting it together. So we'll be taking group one's presentation. Mr. Adedumade is with us. Thank you so much, sir, for joining. We are currently taking presentation from the mentees. Once they are done with their presentation, we'll be getting to hear from you on your discourse for today's class. So thank you so much, sir, for joining. We're happy to have you in today's session. Group one, right? We just finished having two presentation. One, if you are ready, we're ready for you. Please, we can go ahead and start our presentation. Group one's presenter, are you with us?
Please, can you help me share your screen? Because I don't think like my hand is ready.
All right, so just give me a minute. Let me try to do that. Sorry, sorry about the delay. I'm finding it a little bit difficult doing that.
Hello, please. Can anyone hear me?
Yeah, we can hear you. Sorry, I'm trying to share your slides.
Okay, please help me share the screen.
Yeah, I'm doing that now. All right, so there, it's all, if I'm not mistaken. Yeah, can you see my screen? Hello,
Yes, sir,
Blessing,
I
can
can
you
see
see?
your screen. I can see your screen.
Okay, so group presenter, please, you can go ahead.
Please give me a minute. Let me set up some stuff. I'm coming.
All right, please try and do that quickly.
Can you hear me?
Yes, we can hear you. Please go
Can you
ahead.
hear me? Okay.
Yes, we can hear you.
So our topic is on protection and monetization of photography and visual arts works. And the law that usually protects the works of creators like photographers and visual arts is copyright. So first of all, what is copyright? Hope everyone can.
Yes, we can
Um,
hear you.
okay. Copyright is a form of intellectual property that protects creators of literary and artistic works of creators, and it creators the right to reproduce, distribute, and display their works. So a copyright, copyright registration, generally copyright is automatically registered, even like without formal registration, or going through the normal process of just like other forms of trade, of intellectual property like trademark and stuff. So copyright is automatic in the sense that once a creator has recorded an artistic work, maybe in form of writing or taking a picture, the creator has a legal right over that work. So, however, it is necessary that a creator still registers their work with the Nigerian Copyright Commission in order to prove give more validity and enforcement to their work. So so there is also where fair use. Fair use is more like um one of the exceptions to, not really an exception, but ways you could use a copyright an artistic work without being without the permission or the consent of a creator. And one of them is fair use. Um and also I want to also mention that there is kind of an issue that comes up between a photographer, and usually the copyright is between a photographer and the subject of the photography. Who has the right? There is always like an argument or a debate on who has the right. Is it a photographer or the subject? Because the subject of the photography could also has an image right, especially when it pertains to human beings. You as a person, you have an image right. So um so in this situation, who usually the copyright belongs to the photographer. But in such situation, there's still no argument, but like generally the copyright belongs to the photographer. So back to the issue of fair use, not really an issue, just the subtopic under fair use. It's more like a limited use of copyrighted materials without the permission of the owner. For instance, there are people on YouTube that normally does reaction videos. So most times those people doing reaction videos, they could be they um they could be uh there could be a copyright claim against them. So most times creators using this kind of um using fair use usually state it when they want to contest that claim on YouTube. So this is an example of like where fair use is to show that fair use is accepted in a situation where copyright, like even you when you do not obtain consent from the owner of the right. So copyright law and photography, the impact of digital technologies. So technologies have made it easy to replicate, distribute photographies and visual arts. And also most times it's on the creator of the copyright to make sure to enforce his rights and to be vigilant in watching out for any infringement of his rights. So um what this entails that like you as a creator, you don't expect maybe the commission or maybe the government body or something, or maybe the court to be the one to like um to be the one to look out or watch out for any infringement. If you as a creator, the court most times gives you the power, the power to go like to the court to go to the premises where your copyright or your works are being infringed. It could even give you the power to resell, to sell um those those materials that you've used to infringe your copyright, your economic right too. I also forgot to mention that copyright is also in form of like both economic and moral rights, in the sense that like as a creator you have the right to the financial benefits that emanates from those works. And then also you have the moral right, in the sense that you have the right authorship and also right to protect the value of what you have created. So digital watermark and image recognition. Digital watermark is more like a means um whereby creators used to usually impute their watermark, their logo, maybe in the form of their trademarks or their logo or whatever, on their works. For instance, if you go online I want to download maybe all these videos, all these short clips for maybe you want to do a voiceover to share something, or you just want to do a voiceover. Most times you see those videos with iStock or Getty Image. Most of those things are, that's an example of watermark. So it kind of helps to trace the origin of that work. So that's where digital watermark and image, digital watermark comes in. It helps to, it also helps to discourage infringement of someone's rights and also to trace ownership. So in the, and also image recognition is more like a technology that helps owners of rights to be able to detect unauthorized use of their works online. And this like in form of software tools, software that can scan internet for images. So they, so when they scan internet for images, they kind of trace where their right has been. Like maybe for instance on YouTube, if you're using someone's work or part of someone's work or someone's music, it will quickly alert the person on that um your work is being used by someone else. So most of that, those times, those people file copyright claim against you. And please hope you guys can hear me.
Yes, but if you can increase your volume a bit, I think it's going to be much better.
Wait, my voice is low.
It's a bit slow, but it's fine now.
Oh, sorry, I didn't know. But hope you guys have been hearing what I've been saying.
Yes, we have.
Okay. So that's that for image recognition. So in the aspect of blockchain technology for art authentication, um so in the aspect of blockchain, I don't know if we have heard this NFT stuff, like non-fungible token. It's more like an art, and like a digital art that is being sold in the blockchain industry or the digital industry. So so those kind of technology helps to protect ownership of digital work, photographs, and artistic work by creating you know proof of authenticity, stuff like that. So um the impact of this helps to prove enhance transparency and also reduce fraud and also protect the value of works, artistic works of creators and photographers. So um so in summary, copyright using technology has helped creators in protecting their works recently. Unlike maybe those times these technologies are not available, yeah, you could see a lot of maybe people using a lot of copyright infringement. Like even YouTube is an example, our social media is an example. Those times on YouTube we see people using using other people's works, or even maybe clickbait or stuff like that, or even lying with people's works or something. But today, those activities have stopped due to these technologies that has helped creators to trace where their works are being infringed, or where their rights are being infringed and their works are being like used in a manner that undervalues their efforts. So thank you very much. And here's our question. Group one question: how do we effectively make use of watermarks on photographs, on photos and visual work to prevent infringement on social media. Thank you very much. I hope you guys have a wonderful night.
All right. Thank you so much, Blessing, for your wonderful presentation. Well done to you and to your team putting it together. What we are going to be doing right now is we're going to be having Mr. Adedumade come up, and then maybe for the next 30 minutes, we would like to just have him give us his discourse for today, as well as, also help give feedback to the presentation. That's for those that he had, and, while he went through them, what he thought about the mentee's presentation as a whole. And then we'll be taking questions and calling it a day. You're welcome, Mr. Adedumade.
Good evening, everyone. How are we doing today?
Great. You're very fine, sir.
All right, great. So I'm excited to be here. Allow me to initially apologize. I came into the room a bit late. I'm sorry, I had a final meeting at the as early as I hoped. But I came in while the presentations were going on. I got to listen to the presentation of a gentleman before the lady that just spoke. Is it okay for me to confirm that I just those two presentations?
So you said, sir?
Is it
I
only
didn't
those
get
two
it.
presentations? Did we have only two presentations?
Yes, sir, we did. Just to.
Okay, great. Just to confirm, because I heard the end part of the first gentleman, and I also listened to the presentation of the two who just spoke now. Is it okay if I start with my remarks on those presentations?
Yes, sir, it is.
Okay, great. Well, I don't want, I hope you guys don't mind me asking. I can see a lot of names. So I don't know if you don't mind for the next maybe 15 seconds. Do you mind just show your camera? Let's just see your face. You can
Yes,
keep
so,
your phone on mute in case you're somewhere noisy. But let's see your face, yeah.
yes, so please, if it's possible, for the mentees, let's try to have our videos turned on so that we can see our face. Thank you, Blessing.
Yes. Okay, Blessing, I can see you. Thank you very much. Are there
Yes, so
okay?
other mentees, please, can we try to turn on our videos? Okay, thank you, Fina.
Thank you, Fina. Thank you. May you Blessing. I can see Amate. I don't know if that person is found on. But great. Let's move on. So don't take much time. Thank you to two of you for sharing. As a gift to both of you at the end of the session. Yeah. So your presentations have been great. Kudos. I've gone through them even outside listening to you speak to them. I went through them. I think you're fine. Both teams tried. I want to encourage the lady who spoke last. What's her name again? I didn't get her name when she started. The
Blessing
lady
that
who
spoke.
spoke last. Sorry?
Blessing. For a blessing.
Okay, Okoye Blessing. I just wanted to encourage you. Presenting can be a bit tough sometimes. I know. I'm sure as you continue to present, you get better at what you do. So yes, I just wanted to encourage you. Now to go to the root of what you guys spoke of in the presentation. You were able to put together in theory the concept around monetization and protection of creative work. You talked about copyright, which is great. You talked about ways artists, particularly, and photographers can sell their art and still be protected, which is great. You also talked about how to protect the work, which is also great. You also talked about investigating to see where your work has been infringed on, which is great. So I think you guys have covered the field, but not the whole field. What I did not see was I did not see examples of these instances. It is mostly theory. I would have loved to see instances where these laws have been tested, instances where someone sued in one case to protect their intellectual property and what the court said. I would love to see a lot of instances, which I did not see. So next time, I want to believe a lot of us here are young and upcoming legal practitioners, right? Many of us may be students, but we all hope to be a lawyer someday. Knowing the law and applying the law are two different things. What you have done is you have shown that you are capable of researching and you are capable of knowing what the law is, which is great. But applying it is the second leg. So I just want to urge both teams, to look into that in further presentation. Show how the law is being used, not just telling us what it is and how to protect it. So in a nutshell, that's a little bit of my feedback on both presentations. If I have any other feedback, I will share them today. But guys, there's something I really want us to talk about, which is, yes, we've talked about, which a couple of us touched on. We touched on in our presentation, but we never really went deep into it. You see, the biggest threat to creatives now globally is AI, right? The threat used to be that you should go online and look for where your work is being infringed upon, or you should try and find out some way to discover where your work is being infringed upon. But with the creation of AI now, people don't even need to infringe on your work anymore. For instance, if I want a picture of a beautiful vine, for instance, right? A lot of artists and a lot of photographers have created such images. Artists have painted it, photographers have taken pictures of it, and they have shared with the color, the flowers, the lush. I'm sure the lush greens. I'm sure if we go online and we search, we'll see a lot of pictures, both photographs and artwork that are like that, right? But now, all I need to do is go to my AI assistant, right? I just tell it, create this image for me, and it creates an entirely different image from what already exists. Note the word I said, entirely different, which is debatable. But it creates a new image. So I am no longer even infringing on the right of the photographer, because the photographer cannot come and meet me and say the picture I posted is this picture. No, it is not a picture. This one was created by AI. The artist cannot come and meet me and say, oh, this artwork that you used for your commercial thingy, you have to pay me. I'm like, no, because it's created by AI. So the biggest problem for photographers and artists now is AI, because it has gone beyond when someone steals your picture, it has gone beyond you now being relevant. People no longer need your picture. And this is something that people need, that people will steal there. You're going to be fighting and say, you stole it to pay me money. But when they don't even use it anymore, that's the problem. Now, there's a deeper problem, because the AI that has created it was trained on images and pictures created by the artist and the photographers. That's how you train a chatbot. I have a chatbot that I created as well, and I know how I train it. It's a little chatbot, so I know how we train it. So it is just the same thing for these chatbots or these AI assistants that are out there. They are trained on other people's work. Now, how do you prove an AI has used your work? That's very, very hard to prove. An AI creates an image and you painted an image. Can you exclusively prove that that image was an exact copy of your work? Because an AI is not copying just from you, it's copying from thousands of people. So how do you now single out yourself and say, from all the images you copied from me, it can be 100, it can be 200, it can be 50, it can be 10, but my own image is one of them. How do you prove that? It's becoming very difficult. So that's why globally, you see that there's a lot of pushback by the creative sector towards AI and what AI can. I don't know if you noticed a trend about 2 days ago on X, somebody known as Twitter, right, where an AI was launched and was creating images for people. That is the biggest problem for creative now. So as a lawyer to creatives, right, or as a friend to creatives, or as someone who will be in a position to advise creatives, it could be your friend, it could be in a professional setting. You have to be abreast of these things and know how they can start to protect themselves in the world of AI. Now, do you know that the copyright law was the history of the copyright law is somewhere in the 1800s, right? AI has come to change the dynamic of copyright law. I'll give you a classic example. So, for a work to be copyrighted, right, it has to be a human creation. The ghost cannot create a work and say want to make it a copyright. That is why there was this problem, or not the problem, there was this case. There was this monkey. I don't know if someone can tell me the name of the case. So that's just an assignment as we're discussing now. Someone should Google it and tell me there was a case about the monkey who took a picture and they tried to sue for copyright. So what happened in the case was a photographer went to a zoo, was taking pictures of the monkeys. The photographer now left his camera on the floor. The monkey now went, carried the camera and took a picture. The photographer now tried to claim ownership over that picture that the monkey took. But the owners of that zoo, like conservatives, they were trying to conserve, I think, the wildlife to a certain extent. They now sued that no, it was the monkey that owns the picture because it was the monkey that took the camera and snapped the picture. It was even kind of like a selfie. The monkey just had the camera, turned it back to itself, and snapped the picture. And they tried to sue that it was the monkey that owned the copyright. But the court said no, a monkey cannot own copyright. It has to be a human being. And that's what the copyright law says. It has to be a human being. But in the generation of AI now, all that's changed because even the law is beginning to change. So initially, when people made applications for AI copyrighted work, right, it was turned down. It was turned down by the institutions that were meant to register those works. Even when they applied to courts to force those institutions to register the work, those works were the court did not agree with them. The court dismissed their case. And that was the beginning. But now there was a rule, there was a judgment that came out from a court in Asia, China or Japan. And the court was the first court.
Okay,
Came out
I don't know if
sometime last year or maybe last 2 years. I'm sorry, you were saying something?
Oh, okay. I thought you were having a network glitch. I didn't hear you for a moment. Maybe it was from my.
Okay, so am I good? Am I good to go?
Yes, sir, you're good to go.
All right. So has anybody been able to find the story about I said about the monkey? It's online. I don't know if you can Google why you do it. I think the monkey's name was Naruto. Yes, Naruto. So if you
Yes,
find it,
sir.
just post it on the group chat. Is there someone that's saying something?
Yes, sir, I have. I'll share the link on the chat.
Yeah, just share the link on the chat so people can read it. So that was the law before, but now, like I said, in Asia, there's a judgment that says that AI work is copyrightable. Now, the US courts, which has been the biggest defender of creatives for a while now, right? The US court has now changed its law. What the US courts are now saying now is that for an AI work to be copyrightable, it must have a lot of human input into it. So, and they must, and you as the creator must be able to prove that you have human input. Now, what is human input? Just the prompts. So, if you go to your AI chatbot now, I'm sure we all have it on our phones, either on our Facebook, on our X. Some even have the apps themselves. That's ChatGPT. You know, just type something, create an artwork for me that looks like dash and dash, and it creates it. And you now continue to change it. Maybe it came out with the flowers are purple. You can say, no, change the flowers from tulips to roses and make the roses red. Then it changes again. And you can now say, oh, the roses are red, but go back to the tulips and put something in the middle. It changes again. Now it's now say put a fig tree behind it. It changes again. Then you can say put a valley behind it or put a skyline. It changes again. Then you now say put a sunset. It changes again. Eventually, you are not happy with the picture that you have created. What the US court is saying is if you can just prove that process that I just described, then you can copyright the work. That makes you the creator. Because by entering those prompts, you are shown that you're the one that actually inputted. It is not that the chat box just sat down on its own and created it. No, it was your prompt, that helped it to create what it eventually created. So you are automatically the person that owns it. Now the problem is this: how much prompts do I have to show in order to show you that I'm the one that created it? Do I have to show that it was just one prompt that is create an image that's and a great prompt? Or that I had to make changes and inputs and make it and do those changes and inputs and give calls all over again, before I can be held to be able to copyright that work. So these are very big issues that it's really affecting the world globally, and it's affecting photographers and it's affecting artists. And it goes to the root of the two things we're discussing today: monetization and protection. Monetization in the sense that AI is using your work, you're not getting paid for it. Now, people no longer need your work because they're not going to AI to create their own work.
Hello,
So
sir.
you're not getting paid for the work. Yeah. Yeah. You said something. Mhm. Am I being heard? I just want to be sure because I heard someone say hello, sir now.
So I can hear you.
We can hear you, sir.
Oh, you can hear me. Thank you so very much. Because someone just said hello and kind of distracted. Well, Chico's here. Thank you so much. You posted just search for Naruto versus Later. That's the case. Awesome. Thank you so much for sharing that. So that's the case that I was referring to about the monkey. Anyway, so that's even the issue of the monkey. Now, that issue of the monkey involves because the new school debate and the new school topic is generative AI and how it is killing. So I'll just say before I was distracted that monetization as an artist, now if I were an artist, people may no longer be interested in buying my work because they cannot create it themselves using AI. So I'm not getting paid. Now the ones that I've also created before that we used to train the AI that people are using, I'm not getting paid for that. That's on the social. On the issue of protection, my work is being used to train an AI, and I'm not getting the license fee of it. And I cannot even sue the company that is using it Because trying to even convince the court in the first place that I was the one that created the work that they used is a tough job, because all they are going to come and say is that they used 1,000 people's work to create one. And you're going to say, no, out of that 1,000 people's work, my own one is there. How do you prove that adequately to the court? What is the quantum of evidence that you have to show, right, in order to prove to the court that yes, your work is part of the work that was used? So these are issues, and they are very live issues that are happening globally now. A lot of law firms are cracking their heads over these issues. A lot of people are writing briefs on this issue. A lot of people are suing on these issues. A lot of judges are trying to make decisions on these issues right now. And even the economic side too is another huge amazing part, because in these people, now you should understand that the copyright law is there to protect creatives. That is the use of the copyright law from beginning to end. Everything that is there is just to protect the creative, to make sure that the creative is being paid for the work that they have created. Because if the creative is not being paid, the creative will not get money. Imagine all the songs that we listen to, that we dance to when we go out. Imagine if those creatives are not being paid. They'll stop singing. And imagine the dance songs. Imagine all the artworks that we see, beautiful dates everywhere that we go to. Imagine those people are not being paid for that work. What they do, they will stop creating work because they have to feed. So some will buy, some will decide that they want to be bankers. Some will decide that they want to be lawyers. Some will decide that they want to be doctors. Some will decide that they want to start a business and have a shop. Some will decide that it's spare parts that they want to start to sell. Why? Because that is where they have to feed themselves from. Nobody's going to give them money and say because they are creating things. No, they have to still feed themselves. So if they are not getting that anymore, that's the essence of the copyright law, to protect them so that they can continue to create, and we the one are able to appreciate the beautiful things that they create. So if that is at stake, which is what is at stake now, really, because the copyright law is no longer protecting them in the era of AI, right? How do we now move forward? So globally, there are different approaches to this topic. The US is the one I said just passed the decision that said for AI work to be copyrightable, it has to show valuable human input. That's the US. The UK saying AI generated companies, right, should make sure that their companies comply with the Copyright Act, and that it pays those artists that it has used his work to train the AI on the photographers. Put it that way, So that is what the UK is saying. That is generally the concept. So companies like OpenAI, right? They are going through a lot of lawsuits right now. In fact, a lot of us should know about Sotheby's or Christie. They are art auctioneers. So if you're into art, if you like art, and you're trying to look at if art is even valuable, just go and watch an auction of Christie's, Sotheby's. When you see artworks like the size of this one, like that, you could see artworks going for $50 million, $100,000, $5 million. And some of the most expensive works now, the Mona Lisa, is not even priced at about $1 billion. So there's a lot of money in this thing. There's a lot of commerce in this thing. There's a lot of trade in this thing. There's a lot of contracts in this thing. So anyway, there was an example I was trying to make before I digressed a bit. One of those companies, Sotheby's and Christie's, recently wanted to hold an exhibition, an auction, artworks that were created by AI. Now, if we know their history, they've been showcasing works of artists for generations. Right? And what they showcase and what they sell and what they auction is authentic art. But now they wanted to do an exhibition of sale of AI-generated works. And the art community really went against them. Some tried to sue, some went to picket them, some tried to form an online process thing where people form something and tell people to sign an online petition, asking people to sign. I mean, over 20,000 people signed a petition, and they should not do that exhibition. But I think at the end of the day, they went ahead to do it. So that is, in a nutshell, I think I've spoken for a while now, but in a nutshell, all these things that we've been discussing already in our presentation, they are great, right? But they are not the most important issues. I'm not saying they are not important, but they are important. Don't get me wrong. Copyright laws are important, protection of works are important, the monetization of works are important, artists, either photographers, visual artists. But the biggest threat to them now is generative AI. So yeah, in a nutshell, that is that on that. So just a little bit of a roundup on the issues. The lady that was blessing, I think, to mention the issue of the debate between who wants the picture, the photographer, or the subject. That is a good one. The current law is that it's the photographer that owns it. So that is to some people, those pictures may be used. But that is why we are, as lawyers, we have to continue to test the law. We have to continue to sue and try to protect the rights of these people. So yeah, I think that also covers that. And I'm trying to think if there's any other interesting issue, but AI is taken a number of time that I would discuss. And I don't want to go back. I don't want to go back to all of the issues that we discussed across board already. Like I said, I listened to it. But what really struck me was the need for a lot of us to do two things. Like I said, the first one is look at where the law is being implemented, how it is being implemented, and how it affects creatives generally. It's not even visual artists and photographers that are using AI trouble. Even musicians are in trouble because AI is now creating. I can tell the AI, create a song for me in the voice of this kid or Bonobon on the video, and it is going to create it. So there's going to be a problem too. In fact, that problem is already growing for that industry as well, because they are saying if I create that song as someone, let's say me now, just sit here and just on the app, create a song using the Burna Boy voice, I sing the song and create the beat. And it's going to do it in less than 2 minutes. I can now go and post that song online and say, okay, that is my song in Burna Boy's voice. So those are the issues with generative AI. It's a big deal. And I think as young lawyers, it's one thing we should pay attention to. So yeah, just to round up, I think I have just like to wait questions at this time. I hope be able to engage your mind and put it on the and having to disrupt the industry. So yeah, any questions, comments you'd like to share?
All right, so please, thank you so much, sir, for that presentation from your end. So please, we'll be taking questions, right? Mr. Adedumade has discussed some very key vital issues and also raised examples and cases and what is the current trends of issues within photography and the visual art space. So please, if there are questions, we would like to take questions. Though there is a question from group, if I'm not mistaken, from group 2. Let me try and see if I can open their slides again once more. They had a question. Okay, I'm coming 1 minute.
Please, I have a question before it goes off my head.
Oh, all right. Please go ahead and ask your question.
All right. Good evening, sir. Thank you so much for this education. Please, I listened to your class and then I heard you said something concerning the second presenter who happened to be the presenter for first group one. So are you in essence saying that when people sue AI for infringement of their works, it's not possible, like it will not make any sense since AI was made in a way that it takes anybody's work and just, provides it to the general public. Are you saying that nobody can sue AI, I mean, the company of AI, for infringement of their work? Let's say, for instance, now, Davido released a particular song and someone says to AI, remix this song in the voice of Davido for me. That already is on the infringement of Davido's intellectual property. So are you saying that if one decides to sue AI company, for instance, for infringement on their works, it will not make any sense because of this generation? I don't know, I'm trying to look for how to put it. Like, we will not succeed in the action. I want to get a clarity on that, sir.
Yes, so thank you so very much. I understand your question, sir. I'm not saying no one can sue. That's one thing I want you to get right. And secondly, people are currently suing. Even as you and I are discussing now, there are some cases in court on the issue. So I'm not saying people cannot sue. People have already sued, right? That is one thing. But let's now go to the concept of going to court. You understand what going to court is now? You go to court, there is a judge or judges, depending on if you're in an appeal court. You present your case before the court, and you have to convince the court to grant your prayers as they are in your processes. Now, how do you convince the court? You provide evidence to show in support of your. I'll give you a classic example. If someone owes you money and you take the person to court, you go to court and say, this person owes me money, or he owes me an obligation. We had an agreement. He has breached that agreement. This is a copy of the agreement. We both signed it. He has breached that agreement. He has to pay me damages. The court will simply evaluate the evidence that you have provided and make a decision, or grant a judgment, or give an order, or grant an injunction, as the case may be. But in this instance, in the example that you shared, the video on the Burna Boy voice, it is easy to prove because everybody knows the video's voice. Everybody knows Burna Boy voice. If I play a Burna Boy video or Wizkid song for you right now, you'll be able to identify and tell me that is the video, that is Burna Boy. Because the reasonable man on the street, from young child to old person, they know the voice. So that is even easy. If you have that kind of case, you are lucky. But what about when it is now an artwork or it is a picture? How many people know the artwork? How many people know the picture? How many people can identify it if they see it? So that is just what I'm saying is it now becomes very difficult to prove. One of the ways people prove it is when those companies who created the AI systems, when they themselves admit that, oh, we trained our AI of this, and this. You can hold them by that admission. I say, look, for instance, now, let's say the websites called Artsy, or any of the sites that are online that share pictures, even Pinterest, right? If they say, we use Pinterest to train our AI, right? It's easy to hold them if your pictures are on Pinterest. You cannot say, my pictures are there, and they say they use it. So that is, a pseudo confession already. But you might not be that lucky. So you might need to provide more evidence to convince the court. Now you have to understand that the court hands are tied. It is not as if they got that there's AI it's not like the judges individually don't know. But you see, judges don't make decisions based on their own needs. They make decisions based on the law. That's why sometimes you might not accept the decision that the court makes because you feel no that judgment was wrong. To a reasonable man's thinking, you can say no, that judgment was wrong, that judgment was not right. But the court doesn't make its decision solely based on what a reasonable man thinks. That is part of the factors that it considers. But it also considers first and foremost what the law is. It's when the courts decide that the law is infringing on the rights of people that the court will not rightly say, you know what, this law is infringing on the rights of people, is infringing on the constitution, so that law cannot stay. But when that's not the case, they have to follow the law. So in this instance, right, when someone sues, and you have to just imagine you are the lawyer to that person. Someone comes to me and say, I want to sue an AI generative company. The first thing you ask is, what is your evidence? Now, how do you, as a lawyer, build that evidence? So those are questions that we need to continue to ask ourselves. So, like I said, don't forget what I said. And these people cannot sue. People are already suing, even as we are speaking. But convincing the court is an Herculean task. That's what I'm trying to share. Thank you.
Thank you very much, sir.
All
Sir,
right.
I have a follow-up question to that, please. Please, can I go on?
Please go ahead and ask your question.
Okay. Sir, my question now is, this AI of an application is made by, those in the, should I say international world? All of us are in international world. Okay, it's made by people out there. And then, because of gadgets, every one of us, we are having access to it. And our mode of payment is, when we download the app, I think that's where they make their money from. Now, my question is, I don't know what the AI, not just the AI, but what the international court would do when infringement on AI, that's the infringement on their people's intellectual property by AI would do. Because I feel that it is not just enough for each country's jurisdiction to entertain such matter. For me, I think my opinion is that, hello, sir, are you there? Oh, Mr. Dennis, should I continue or I should write it down? Because I think he's no longer on the call.
Okay, please
Hello?
write down your question.
Okay, all right, sir.
Yeah, write down your question. Okay. Mr. Didumade is no longer on the call. So I will try to see if I can get through to him. Okay, please, we'll be giving him, I think, about 5 minutes to join back in. If he's unable to join, maybe because of severe network issues, what we'll be doing is that we'll be sending your question over to him. And if he has a response, we would be sharing, we'll be sharing it with the entire, we'll be sharing it with him. And if he sends a response, we'll be sharing it with the entire class, right, on the main platform. So please, let's just try to hold on for a minute or two to have him join in. Our second mentor for today that was supposed to be in class, Miss Onajite. is not feeling so well at the moment, so she'll be unable to join in for the session today. Sincere apologies for that. Okay. Mr. Adedumade, thank you so much for joining back. We're happy to see you able to join back in. Fina, are you with us?
Sir.
Yes, apologies. I get to my network. Apologies.
Yeah, all right. So
All
Fina,
right,
please, you
sir.
can go.
Okay, sir. So my question was, I was thinking, in my opinion, that knowing that these applications, let's say for instance, the AI, the ChatGPT and every other apps we're using, where there is a breach of infringement by AI on people's intellectual property in any jurisdiction, I feel that this should be matters that should be entertained by an international court, because my reasons is that not all jurisdictions might have a knowledge of intellectual property. And I believe in Nigeria, intellectual property is just a newbie, has not really gotten so much space, like, notoriety in Nigeria. So, but I feel that the international world has this. And so, wherever there is a breach of infringement, like AI picks up somebody's work, through and infringes on the person's intellectual property, courts that should entertain such matters should be an international court. So, what do you think about this?
Thank you for your question. That's a very good question. Now, two things. Number one, assuming you are a lawyer, right? And a client tells you they want to sue at the international criminal, at the international, at an international court. Do you know how much it will cost? Going to the Federal High Court in Abuja, going to the High Court in Port Harcourt, or going to the High Court in Lagos will pale in terms of cost compared to that. Because now you have to think that your lawyers have to travel. Either that or that you get a lawyer who is there. That is one form of cost. How many artists can afford to pay that cost? You are the lawyer now. You will not do it for them for free. You too, you have to eat. And that's why you went to law school, to be called to the bar. That's why you went to uni, to study law, so that you can become a lawyer. And when you become a lawyer, and if you decide to practice, you intend to build a career and earn from that career. So you are not going to do free work for them. That's one. So how many people can afford to do that? That is one. Then secondly, it is now an issue that is even bigger than the International Criminal Court. Not in the sense that it is not an international issue that should get the attention. That's not what I'm trying to say. What I'm trying to say is that it is affecting a lot of people everywhere. It is affecting creatives in Lagos. It is affecting creatives in New York. It is affecting creatives in Dubai. It is affecting creatives in Somalia. It is affecting creatives in Russia. So everybody cannot go to an international court. A lot of them will seek redress in their own local courts, especially when those companies have an active office or have an active person in their company, in their country. For instance, in the US, those countries have an active presence in the US. That's why you can sue them and it's easy to serve them. But imagine me from Nigeria, I want to sue a company that is based in Silicon Valley. And you're telling me I first have to go to the international court and sue them. And now, wow, just me trying to think of that process alone is quite daunting. So I agree with you to the extent that there should be an international body that is taking on these issues head on. And that is also strong enough to provide sanctions, or to give a judgment that will be executed, right, or will be followed. That is a good idea. But not everyone will be able to access that, one. And two, people are still going to try and look for local solutions within their community. and within their territory. I hope that answers the question. Thank you.
All right. Thank you, sir. Yes, sir. Yes, sir. Thank you, sir.
All right, thank you, Fina and Mr. Adedumad. Okay, we'll be taking the question on the on the slide, and then maybe take one more question and call it a day. The question here is, how do we effectively make use of watermarks on photos and visual works to prevent infringement in digital space, particularly on social media?
So it is even easy to create such maps. There are so many apps on your phone that you can use for that. Even right now, as we're speaking, the most common is for sports apps like Canva. And there are a tutorial of them, you know, on your stores, irrespective of which phone you use, right? Where you can get apps that can help you add a watermark to a photograph. Now, what that does is it discourages people from using the photograph because you cannot post a photograph that has a watermark on it. It just doesn't look right. So, yes, that will protect you. But there are also other ways. For instance, there is metadata. You can also inscribe metadata on your creations, either a photograph or a work of art, right? But the disadvantage of some of those tools is that there are only certain apps that can read the metadata on a photograph or on an artwork, right? Or on a downloaded image. Not all apps can read it, but some apps can. So that is what some other people do aside from what I'm actually. Another thing people do is they post they reduce the quality of the image when posting, right? They post a picture that has a lesser visual quality so that way, even if people steal it, one, they are not getting the real thing. Two, they are getting a watered down image, which even when they try to use, they cannot use successfully. For instance, a number of you might know about printing. When you print an image on a t-shirt or you print an image on a cup or on a diary as a souvenir or something, you have to use a high resolution image, right? You may have even sent an image to someone to print for you, and they'll tell you, no, please send a high resolution image of that work, right? So what artists are doing and creators are doing is they are posting images with low resolution online so that even if people try to steal it, they cannot use it successfully, depending on the form of use. So yeah, I hope that answers that question.
All right, thank you very much, sir. I'm sure it does. So please, from the participants, do we have any other person with a question before we call it a day? Do we have any more questions? We'll be taking one question and then we'll call it a day. Do we have any other person with a question?
Okay, please, I have a final question.
All right, go ahead for now.
Okay. So far I've learned a lot on intellectual property and its infringement and matters of intellectual property in the Nigerian courts, like I mentioned earlier, is not so known. I mean, a lot of people are just coming up with cases on their infringement of their intellectual property and so on and so forth. So, sir, please, my question is, if I decide to become a judge, is it possible to practice strictly on intellectual property as a judge? Please, I know this is out of the class. Thank you.
Okay, very good question. First of all, you can be an expert in anything you want. And if you're already thinking of being an expert in copyright law, that is wonderful. I say go for it. Now, in the terms of the role of a judge, right? A judge doesn't have as much freedom as a lawyer in the sense that a lawyer can decide that all I want to do is intellectual property law. All I want to do is maybe litigation. Maybe all I want to do is commercial law. All I want to do is maritime law. You know, a lawyer can decide that and stick to it. But judges, usually, from my experience, right, are not so enabled. For instance, you can find out that a judge can be moved from one division to another. Now, our courts currently sit over a lot of matters from criminal to civil, right, to contractual and whatever. So judges are not at liberty to really choose, or if I can say, to really pick and choose and say, these are the issues I want to try. You can be in family courts today. For instance, now there's some courts that are designated as family courts. The only cases that go there are cases including divorce, maintenance, custody, you know. A judge can be there today, and next year you heard that they moved that judge to the criminal court. That judge will now begin to hear issues that are criminal in nature. You can also hear that that judge has also been moved to the commercial courts, and that judge will continue to hear cases that deal with commercial cases, contracts, breach of contracts, and things like that. So I don't think judges are at liberty to actually pick and choose like a lawyer can. However, judges also build credibility, also build, um, should I say, capacity in different areas. There are some judges that are known for, like now, there's a judge in somewhere up north. He is known for being an IT person. He knows a lot about IT. I just can't remember his name right now. He knows a lot about IT. He speaks on IT at MBA conference. In fact, if you want to recall two people from the bench on IT today, he is one of the. He is the number one, right? I just can't recall his name at this moment while we're speaking. So that is someone. So you yourself, you can build capacity and expertise in any area of law that you choose, including intellectual property law. But as a judge, that doesn't mean that's what you would do only, except if in the future the government now creates intellectual property courts as a special court on its own. Then if you're a judge in that court, you know that it's intellectual property work that you'll be doing. But at this time, we don't have that. I hope that answers the question. Thank you.
Thank you, sir.
All right, thank you very much, Fina, for your questions. Thank you, Mr. Adedumadi, for helping us answer those questions. I'm sure with everything that's been said in class today, from presentations to Mr. Adedumadi's discourse on, the current issues in and how AI is now like the latest challenges that people and photographers and people within the artistry space are going to face or are currently facing, right? I'm sure his discourse has enlightened us and opened our horizon towards this particular field of discourse and ways we can navigate around it. Also, the questions I'm sure must have brought one or two insights that we have learned from. And think with this, we say for us to call it a day. Thank you so much, sir, for your shared knowledge and all your insights in today's session. We really, really do appreciate your efforts. So good night,
My
everyone.
pleasure. Thank you
Please,
for having me.
thank you very much, sir. So to the mentees, please do not forget to fill your attendance, share what you've learned on social media, as well as tag our mentors while you are doing your postings. Good night, everyone, and please enjoy the rest of your evening.